Testing 1 2. Testing 1 2. Testing 1 2.
All right. My name is Phil Daniel. I'm the chairman of the Cobb County Board of Elections. And I'd like for our other board members to introduce themselves.
Vice Chairman.
Wilson, Commissioner appointee.
Jessica Brooks, Secretary.
Here, Assistant Secretary.
And at this time, I'll turn it over to our attorney who will let us know the procedures that we'll be following during this hearing.
Okay, my name is Greg Litchfield. I represent the Board of Elections. And basically, we have a challenge to which the challenger will present their case, and he has the right to call witnesses or present evidence. And then the candidate being challenged will have the same rights. They will have the right to and submit evidence. There's no time limit. The one thing I do request is we do have your written. I would like for you, in order to, I'd like to get this over as quickly as possible without saying, you know, if we have to stay here forever, we will. But when you present, try not to argue. I mean, at the end, you'll be able to make a summation, but, you know, present what your challenge is. So we'll start with the challenger, and this is in the case of.
All right, my name's James Herndon. I'm a voter here in Cobb County, and I'm bringing this as an elector to challenge the candidacy of Sheriff Warren. Most of everyone here, I'm assuming, has my written complaint that I had to file by law. To make this go as quickly as possible, if everyone has my complaint, that's basically what's in there. When you start off with the first challenge, there are 4 challenges altogether on Sheriff Warren's qualifications. On the first challenge is a sworn of candidacy and affidavit. If you note at the bottom of that form, it is not notarized, it is not sworn to. In the state of Georgia, a notary can take a sworn statement, can take an affirmation, but under Georgia law, and I have the law spelled out in there, under Georgia law, the only time that notary can act in that capacity is when they affix their seal or stamp to their work, to the signatures. None of the 4 documents that I'm challenging in my 4 challenges did Sheriff Warren affix at his notary, if it was a notary. As you cannot see who the notary's name is, I don't know who the notary is to challenge. There's no name, there's no stamp. Under Georgia law, it has to have the on there that indicates the state and the name of the notary. We don't have any of that there. And when you look at the law on that, it actually spells out that you cannot take an oath, you cannot do any of those things without your notarial stamp. You have to have that or it makes the act invalid. That's the gist of the majority of what I've got here in these challenges. As far as the first challenge, I have an issue with that one. It's not a statement that the code section calls for to qualify for the office of sheriff, because he did not swear it before a person that was authorized to take an oath, because if that person happened to be a notary, they did not commit a notarial act by placing the stamp on the paperwork, so it's not a sworn statement. It would be the same as I found the guy out here on the street and got him to sign my paperwork and just turn it in. We have people who stamps on things. We have a notary with powers given to him by the state of Georgia. We can attest that we have a person that can actually give an oath and affirmation. And when we don't do that, it impinges the process, because we don't know that that was actual proper oath given. In this case, there's no way to go back in time. You can't unring that bell. There's no way to correct it. It was submitted. It was turned in. 4 different pieces of paper altogether, and for qualifications. The sheriff has been through this process 3 times before. I've seen his paperwork before, and it had notary stamps on it, and that did not occur. The notarial stamp is so important is if a person makes a false statement on that, without the notarial stamp, without it being a sworn statement, you can't prosecute the person for it, because it wasn't sworn. So, I'm not saying anything's being hidden on the form, but if there is, that would be a good reason not, if you're putting any information on there that you know not to be correct. Because when you don't swear to that statement, then we can't prosecute it and move on with it. If you do swear to the statement, you make a false statement, then it's really an issue. But we put a lot of power in notaries. We put a lot of power in people that give oaths and affirmation. Had the sheriff had it sworn out before a judge or even a clerk that was authorized by a judge, I wouldn't be here challenging this. But this is some unknown person that signed this document, some unknown person that alleges to be a notary that did not complete the notarial acts, which is actually a misdemeanor crime in the state of Georgia to not affix your stamp. That paperwork and attempt to turn it in, that's what we have here. So the first and second challenges, without, I don't need to bore you to death if you've been through that, that's the issue on both of those. The second challenge, it suffers from the is the affidavit for sheriff, where it indicates it must be sworn under Georgia law. It says on the form, this is Exhibit B, it states that David is to be sworn or affirmed before the officer with whom such person is qualified to seek said office prior to the time of qualifying. Well, if the person did not affix their notarial stamp or complete the notarial act, they are not qualified under Georgia law to take an oath or affirmation in that capacity. Going on to the third challenge, Sheriff in his documents to the probate court that he is submitting an affidavit. And in that affidavit, I'm going to pull that up, that's going to be Exhibit C in my complaint. It says, now comes a sworn candidate for the office of Sheriff of Cobb County, Georgia, and files this affidavit in compliance with OCGA 15-16-8 and Georgia laws 2003, pages 3712 through 3714, and on oath swears that the following is true and correct. Again, we have the same scribble at the bottom. Georgia laws, a scrawl, a scribble is not sufficient to meet the notarial standards of a sworn statement, and that's what we have on all of the documents that we have presented here. This is more clear where you put the wrong year or you mark the wrong. This is a critical step in the legal process to ensure that this document was in fact sworn and attested to before a person that had the authority to do so. And in this case, for whatever reason, on all 4 of these documents, occurring on different dates, by the way, occur on the same date, we don't have the notarial seal. A notary cannot notarize anything in any capacity without a seal or a stamp. It's just not allowed. You can go back in case law for as long as you want. You'll see as long as we've had notaries, that was required. The other issue I have in the fourth challenge, the paperwork in the fourth challenge also the same flaws in the first three. And that is going to be, just give me a second here. He's sworn affirmed before an officer. He's supposed to qualify before the officer that qualifies candidates. I'm challenging if the person that made that scribble at the bottom of the sheriff, Exhibit B, if that person was in fact a representative of the Republican Party, capable and an officer in that party that can use their affirmation to qualify sheriff. It looks like it's the same scribble to me on all four forms. And again, this form also suffers from the same thing. It was not sworn and attested to properly under the law. I again don't see how that bell can be unrung. I don't see how that can be remedied. It's all turned in, it's qualifying is over, and this was not corrected. And to my knowledge, it still hasn't been even attempted to be corrected to this day. That's basically all I have on that. If you got the written challenge, it'll have a whole lot more detail there. And of course, when we get to questions, you have questions, please ask.
Sheriff Horn?
Yeah.
Good afternoon.
Let me, go ahead.
Good afternoon. My name is Nathan Wade. I'm an attorney, and I'm appearing on behalf of the Sheriff Warren and Chief Allen here in efforts to sort of short circuit the entire process, but without undermining the integrity of it. If you would, I'd like to just start calling witnesses to get into the heart of Mr. Herndon's allegations, if that's okay?
Sure.
Okay, so the first witness we'll go ahead and call will be, let's call the Tanya Boga and Jason Shepard as witnesses for the Republican Party portion of Mr. Herndon. Is that okay?
That's fine.
Could you repeat the name of the first witness?
Tanya Boga and Jason Shepard.
Say that again, please.
Tanya Boga and Jason Shepard.
The acoustics in this room are not great.
I understand. We good?
Yes.
So should I go?
You can. They can.
So, I guess for logistics,
We're getting another chair for you.
okay.
Put them 6 feet apart.
6 feet.
Where's Louis?
Yes, that'd be fine. I was just wondering what we're doing.
Yeah, would you raise your right hand and state your name?
Jason Shepard.
Tanya Boga.
Testimony you'll give in this hearing with the truth, the whole truth, and nothing but the truth, so help you God.
I do.
So you've introduced yourselves and you've been sworn. I will, just for the sake of time, lead through sort of the introductory portion of the hearing. Are you both attorneys?
Yes.
Yes.
Are you both qualified to qualify? Are you qualified to qualify individuals within the Republican Party?
Yes.
Mr. Shepard, your position.
Chairman of the Republican Party.
Ms. Boga, what is your position?
General counsel.
Have you had the occasion to qualify before?
Yes.
How many, Mr. Shepard?
Personally, 3 or 4
Over the
3 years I've been chair.
same question, Ms. Boga?
I don't know the exact number, but over the years that I've worked with, probably, I know upwards of
Specifically, Mr. Shepherd, are you authorized to qualify for the Republican Party?
Yes, as chairman, I am.
And who, I guess, empowered you with that?
I was elected by delegates who were elected out of the general after the call of the mass precinct meeting, both first in February 2017 and then again in February of 2019. The delegates elected there at the county convention elected me and then re-elected me in 2019.
And are you currently the chair?
I am currently the chair.
Your credentials are otherwise up to date?
Yes.
Ms. Boga, what qualifies you to sit in a room and qualify candidates for the Republican Party?
I'm an officer of the party, general counsel, and as such, that is one of the things that I am qualified and often do for the party.
Were you elected to your position or were you appointed?
I am actually, the members vote me in once I am submitted as the person of choice for the appointment, and then there's a vote.
Mr. Shepherd, in your role as chair of the Republican Party, are you vested with the duty of making certain that candidates who come in to qualify are actually qualified to do so?
Yes.
Explain to the committee how that's done.
Well, the candidates have to sign an affidavit that's provided by the Secretary of State, an affidavit of candidacy. They fill it out with their information. They complete it in front of myself or one of the other officers who are acting on behalf of the Republican Party at the time. And that signature, of course, is notarized. After all the candidates have qualified, and at the end of the qualification, I have to sign an affidavit along with the Secretary of the Cobb County Republican Party, as directed by the Secretary of State of the state of Georgia, attesting to all the candidates who have qualified. And that is presented with all the individual affidavits. And we have brought a copy of that with us today.
In this specific case, Ms. Boga, were you the representative qualified Mr. Warren?
That is correct.
Did you make certain at that time that he was actually qualified to qualify for the position?
Yes, I did.
Explain to the committee what you did to make certain.
When Sheriff Warren, candidate Warren came into the office, I provided the documents that needed to be completed on that day and that were necessary for him to qualify for the position that he was qualifying for. Each of the positions that I qualified people for were different. And we made sure that he had all the proper documents, and I had him to review them. He had several staff members with him. I asked them to look at them along with him to make sure that he was completing them the way he wanted them to be completed, pointed out specific things to him that he needed to pay attention to, observed him as he was completing the process, and when the notary also notarized his documents. Once that was completed, the next step was to make sure that they were all file stamped in. You have to have them stamped. Someone to make copies. He received a copy. We retained copies in the office, and I also retained the originals, which I kept in a separate file. The originals, I oversaw all of these the entire week. We dropped things off that needed to be dropped off on Friday, qualifying process, and we have retained custody of the documents since then, and I have them here today.
In your testimony, you identified a notary that was present.
A notary attended and notarized the documents, and she was from the sheriff's office, as I was told.
Is there a seal or stamp that can, or does the notary bring their own seal or stamp?
Each notary has to bring their own.
Are you, or were you familiar with, in fact, the document that Mr. Warren signed to qualify? Were you familiar with whether or not that document was actually notarized?
It was notarized in my presence in the office on that day, yes.
Was this the very same document that you, Mr. Shepherd, would have had to examine to make certain that everything was proper as the format?
That is correct.
That is correct.
I'm gonna hand you what I'll mark as Warrant Exhibit 1. Would you tell the committee what you're looking at?
I am looking at Sheriff Warren filling out papers and getting ready for them to be finalized. Looking at the notary standing beside him.
How do you know that's a notary?
That's what she told me when she came into the office. Well, actually, at first, I was qualifying someone else when they arrived, and one of the assistants in the office knocked on the door and told me that the sheriff's, notary had arrived. And I said, okay, and when I brought them in, she was identified to me as the notary from the office.
Specifically from the photo.
If I may, before we go further, this photo, who took it, where was it took, when was it took? None of that's been laid, any kind of foundation. I don't know what you allegedly qualified. That could be the first time, the third time.
Can we cut to the chase?
Absolutely,
Do
but
we
if we're
have
gonna,
the original qualifying documents?
Yes.
Can you present those?
Yes, that's what I'd love to see as well, sir.
I'll present the documents as you tell me from that photo.
Oh, and I
We
see
still don't know
myself.
where they came from, so I don't know how that's relevant.
Using courtroom rules here? Because
Well,
if we are,
It's an
then
administrative hearing, so the rules of civil procedure don't apply.
I'm not an attorney,
Yeah.
he's here with two attorneys,
So, I
I'm
mean,
just me.
it's a lot more,
It is, I just don't know where the photo came from.
so if
well,
we're,
you can answer where did the photo come from?
Yeah, who took it, any of that.
I'm happy to do that, but if we're gonna use rules, let's hold Mr. Herndon to those rules
Until
as
you're
well.
finished. That's correct.
So, Ms. Bowden, what's in her hand?
The part of what she uses to notarize, is the stamp that she's going to use to notarize the document.
Would that be a notary seal?
That would be considered one.
Is that the very same seal that's on the document that you brought here today?
That is correct. That's the one that she used on that day, and that would be the one on the document that I. Oh, and I also see my hand here holding some documents.
Oh, absolutely.
Yeah, sure. On this declaration of candidacy, on the bottom left-hand side, what do you see?
I see her name, I see her signature, I see the seal, I see
Okay.
the date of expiration, and when the notary expires.
If you don't mind, can you speak up just a little bit, please?
So for the board members, I'm going to pass this around and let the record show that there is a seal on the document. That's the embossed seal. Is it the I'm glad.
That document, that's the, in fact, the original document, Ms. Bogan, Mr. Shepherd?
Yes, sir, that is the original document.
Has that document been altered in any way since the date of qualifying?
No, sir.
Where's that document kept?
It is kept in the chairman's office in the filing cabinet at headquarters.
Okay, on the affidavit for sheriff, can you tell me, is there a seal on the document?
Yes, there is one. It's right here, and if you can't see it, you can touch it and feel it.
Right. If we had some carbon paper, we probably, or a pencil, we probably could do this to get the
tell you what the glass?
Well, with that, if you need the magnifying glass, I don't know if you do, you may not.
What is
You
the
mean,
name, what is
it's
the
actually
name
sealed,
on
it
the
says
seal?
Cobb County.
And it's got the name on the seal. Can you tell who the name is?
We'll simplify it because she's next.
The name is Kimberly Moore.
Okay, all right.
I didn't understand what you're asking. Yeah.
I'm sorry.
Yep, I can see it. Yeah, if you get the light just right, you could read the name.
I also, the affidavit that was filed with the probate judge does not go to us. It goes to her. So the probate judge is here with the original affidavit. If we need to call her to look at it.
If it has a seal on it as well, that clears it up. When I
And-
filed my challenge, had I simply been told by the board that, hey, we have one with a seal on it, it should have died there.
Understand, Mr. Herndon, are you withdrawing the challenge?
If all of them are sealed, yes, sir.
I have the
That is
other-
that is my challenge.
So if that's the crux of the challenge, the challenger is just withdrawn the, you have the original?
It's right there.
The challenger
Would
is
you
just
like me
withdrawn
to
the
get
challenge?
Uh,
the affidavit from Judge Walt?
Says it's sealed, it's sealed.
She does, and she actually emailed me before I asked her to bring the original, telling me that it was sealed.
That's it, sir. I wish someone would have actually done the election until we would be sitting.
We have to go through the procedure. And at the time, I mean, granted, we get copies, and you can't tell in the copy if it is sealed. And that's why.
I've never seen that happen myself, personally.
An embossed?
Seen it and it not pick up on a copier. I see it now.
So, to the committee, for your time, if the challenger has withdrawn the challenge, I see no reason to belabor the point or hold you any longer. I appreciate your time. Are we free to go?
You are.
Enjoy your day.
Thank y'all.
Oh, thank you. You're not on the situation,
Now call our meeting back to order, and I will now turn it over to our attorney.
Well, you have to call, you're going to call a new, you're going to do the same thing over, like you introduced everybody, because it's a separate hearing.
Okay, I thought it was all on one straight. Okay. I am the chairman of the Cobb County Board of Elections, and I'd like for our other, Phil Daniels, to have our other board members introduce themselves.
Fred Aiken.
Darrell Wilson, Jr., Commissioner appointee.
Jessica Brooks, Secretary. Aaron Wallace, Secretary.
I'm Greg Litch, Board Attorney, and the rules of this hearing are that the challenger will present his case and can call witnesses and submit evidence, and then the candidate being challenged can also call witnesses and submit evidence and can respond. And there's no time limit, and as I told the we have a challenge, and if you would try and make it succinct so that this hearing can go as long as y'all want, and make it close up in order to get our board members and y'all on their way. Thank you.
Okay. If I could make a point of clarification, are you doing openings, or I know this is informal?
It's informal. He's going to go first,
Okay.
so you can do an opening after he goes.
All right, and I don't know if you need an entry of appearance.
No.
But, okay. Prepared one. Thank
Yes.
Good afternoon, Board. I'm Surgeon. I'm a voter and elector here in Cobb County, and I brought this challenge pursuant to Georgia law to the qualifications of Gregory Bernard Gilstrap. After examining his qualification paperwork, I found that he did not submit a required affidavit per Georgia law 1516(1)(c)(3) to qualify for the close of sheriff by the close of business on March 11th. March 11th, 2020 was 3 days after qualification was the previous Friday. That law states each person offering his or her candidacy for the office of sheriff shall file an affidavit with the election superintendent of the county by the close of business on the third day following the close of qualification period, stating that such person is a high school graduate or has obtained the recognized equivalent in education and training as established by the Georgia Peace Officers Training Council, and when and from what such school person graduated from such recognized equivalent training. Upon review of the paperwork of Mr. Gilstrap that you should have before you and attached to my written complaint, he did not commit 1516(1). He also swore out an affidavit. In his affidavit for sheriff, he swore and affirmed properly with a notary stamp that he would in fact, so not just OCGA 1516(1) telling him he had to do this, he also filled out an affidavit with his own hand, notarized and sworn to and turned in, saying that he would in fact comply with this code section. He had to turn in an affidavit saying that he had graduated from high school or obtained the looking at his paperwork, he did not do that. One of the other requirements was he was supposed to turn in a certified copy of his birth certificate. Mr. Gilstrap did do that. He turned in a copy of his birth certificate, but chose for some reason not to file the affidavit as required by law. Same law, the 158 other sheriffs in Georgia have to follow to qualify. It's the same one all the other candidates would have had to qualify. So he swore on oath and promised that he would do this. He had it in the law, and he had that additional reminder on the affidavit that he signed and he turned in his own hand, and he still did not comply with this law. There are other candidates that did. He did not for some reason. But it seems to me relevant that he saw it because he complied with part of the code section that said turn in a certified birth certificate, but did not turn in the affidavit. Not question whether or not he went to high school, question about the letter of the law and what the law says. The law says you have to fill that affidavit out and you have to turn it in and you have to have it in the election superintendent's hands within 3 days. That did not occur. I still don't know that it's occurred. So basically the question before Gregory Gilstrap turned in the required affidavits as prescribed by Georgia law to qualify for the office of sheriff. I think when you look at his paperwork, it's no. I don't have anything to present because he did not turn it in. What you have before you is he didn't turn the paperwork in. Do we have the original paperwork from the Democratic Party? If I could look at that and put that in the evidence, so to speak, so we can look at it, make sure sure that there's not an affidavit in there. We can both just look at it right now. I can mark it as honorable, so I can get it in more detail if you don't, if you think that suffices.
Okay. There's a second affidavit. The letter attached to it, certified copy, certified copy of high school diploma showing graduated in UA.
See anything in here that specifically says they graduated from a certain high school?
If you look at a certified diploma, it has the date on there.
Okay, so we'll continue. So, all right, so the paperwork is what I thought it is. Okay, so it looks like it's going to be in question. I'm not questioning whether or not Mr. Gilstrap went to high school. I'm not questioning whether or not he has GED or any of that. Did he follow the law that says you have to turn in an affidavit that, again, try not to chew up time, that specifically says each person offering his or her candidacy for the office of sheriff shall file an affidavit with the election superintendent of the county by the close of business or day of business following the close of period, stating, A, that such person is a high school graduate or has obtained the recognized equivalent education and training by the Georgia Peace Officer Standard and Training Council. B, in and from what school such person graduated from high school or obtained equivalent education and training. They're looking at that. I see no affidavit that specifically says what the code section calls for. Now, on one of the other affidavits, go to that real quick. It's going to be the affidavit for sheriff. On his affidavit for sheriff, if you follow along with me and go down to the bottom right before the A and B, it breaks itself off in the paragraph. It says, I shall file an affidavit. In other words, this affidavit doesn't count. It's saying you will file an affidavit on top of this one. I shall file an affidavit with the election superintendent by the close of business on the third business day following the close of qualifications period state. And again, we have the same language. I've obtained a high school diploma, when and where I did it, and that I have the equivalent education. In addition, I shall file a certified copy of my birth certificate with the election superintendent. He filed a copy of his birth certificate, but he did not do the don't know why. This is a second affidavit swearing and affirming that he will complete the affidavit he has to do and has to turn to the supervisor within 3 days of closing. So we've got the code section telling him he has to do it. And then we also have an affidavit completed in his own hand, notarized by Matt Southwell, a person with the Democratic Party here in Cobb that he qualified before. He swore and affirmed that he would turn that affidavit and do it. And that is that's the bottom line on that challenge. It's just simply not on there. If you want to address it challenge by challenge, will that help you out, or do you want me to go, or do you want me to go through them all first?
No, that's fine.
All right, so we'll stop.
So you're talking about the second affidavit you said?
He did not complete an affidavit. We can't look at it because it's not here. So on the affidavit for sheriff,
Okay.
I can show you.
We can say that the package Mr. Litchfield shows is what was filed with the election. So
Yes.
And that we stipulate there's two affidavits.
Correct.
Okay. So you're saying there should be a third affidavit?
Correct.
Okay.
I could.
Yeah. There's the package.
Where's the?
Right.
This is what's in question. Affidavit for sheriff.
Right.
He completed an affidavit saying he would complete this affidavit and failed to do so. That is what I'm arguing and challenging with. It
Even though the second affidavit said he's completed everything?
does not exist. The law specifically calls for him to fill out an affidavit stating those things, and it does not exist.
Okay, we contend it does, okay.
Go ahead, sir. I'll see.
For the sake, if we can stipulate it, do you agree, because I have two witnesses, Jacqueline Metaphor and Matt Southwell, both of the Democratic Committee, that one's under the weather, that testified telephonically. But he came in there, submitted all the package. They, in turn, and I saw on TV the other testimony, they submitted everything to the superintendent and the election board. dispute that, or,
It's not everything.
pardon?
It's not everything he did.
No, I mean, do you stipulate the exhibit, the qualifying paper?
That is the paperwork he turned into them, yes.
And that was submitted to the board and superintendent?
That appears to be the case, yes. I'll stipulate that is the paperwork that he turned in. That is what I'm challenging, that it's missing the affidavit it should have.
Are you challenging the fact that it was turned into the Democratic Committee, superintendent, or not?
No, sir, no. It's just
Okay.
straight missing from the package.
Okay,
Doesn't exist. What my challenge is.
okay. So with that, because I had them to qualify, somewhat like the Republicans had people testifying, but it seems like there's no objection as to them processing the paper. Everything was submitted correctly to the superintendent election board to comply with that part of the statute. Is that correct?
No, he did not comply with every part of the statute.
No.
He's talking about complying with the qualifying.
Right.
I mean, with the party, qualifying with the party.
Right.
To a point, except for that document. That is the final thing you have to do to qualify.
But that's not done.
It's qualified, you have to turn an affidavit to the election superintendent.
But
And
he's-
that I see is not done. That is the crux of this whole challenge, is that affidavit doesn't exist because he didn't do it.
So turning it in with the party, even though they, because the testimony, I think, it would be from the individuals, is that they're empowered from dealing with the election board, is that they submit everything. They don't have to submit it separately. The election board is done through the party, submitted to the election board.
If they submit what they have, and when you talk to them, they'll point out very quickly, they're not legal experts. If you need legal advice, doing your
I'm not
paperwork,
talking
you do all that
legality.
kind of stuff, but fill out the paperwork, hand it to them, and give it to them. If it's right, it's right. If it's not, it's not.
Okay, well, that's what I'm asking. Are you saying the paperwork he submitted, the two affidavits don't comply because a separate affidavit was not sent to the
Those
election
two
board?
affidavits comply with two parts of the code section. There's a third that he did not comply with.
Well, we can get into that, I understand that.
That's what we need to get into then, that's it. He's missing that affidavit.
Okay, and you're talking about a third affidavit that is filed with whom? So if
The election superintendent,
the affidavit with the Democratic committee, you're saying is not sufficient, or is sufficient?
the law says to file it with the election superintendent.
So you're saying it's not?
As you probably
Okay.
know, I was a candidate, and my paperwork may be here, I'm not sure. But
Okay.
if you want an example of the affidavit that I'm talking about, I filed one.
Okay.
Election superintendent,
And you
had
didn't
it
go,
stamped in person, turned it in,
okay,
everything.
and you didn't go through the Democratic committee?
Did the same paperwork your client did with the Democratic committee. I read that and says, hey, by the way, within 3 days, you have to do this with the election superintendent. So within 3 days, I actually did it that day. I went down to Cobb Elections and I filed that in person
Okay.
to make sure it got there because I wanted to be in compliance with the law.
Okay. Now, do you have any objection to the package he submitted, the two affidavits we were talking about in the package were both submitted on March the 2nd, 2020, within the qualifying period?
I don't see anything wrong with them other than
Okay.
he didn't comply with
That's his third
his
affidavit.
own affidavit
Okay.
saying that he would do the third affidavit.
If there's anything about a third. Okay, I understand what you're saying, there's supposed to be a third
That's
affidavit.
what we're here
Okay.
for.
All right, so we'll have to call them, all the witnesses.
Sure.
Okay. You want to go into the second, or you want to get
Whatever
the
you
parties on the phone?
whatever you want me to do, sir.
Whatever.
I can go ahead on to the second one if you'd like, or can we
What's
do
easier for the
witnesses at the end?
To Litchfield, what
You can go to the second one.
Okay. Okay.
So, Mr. Gilstrap, I have a second challenge. It's kind of multifaceted, a little different, so I'll try to go over this. Y'all know the office or sheriff has got that's why following the law is key. There's no one qualification that's outranks the other. They all have to be met to run for this office. My challenge here is Gilstrap did not certify to the Cobb County Probate Court the name of a chief deputy that met the same qualifications that he alleges that he has for sheriff. So in Cobb County, to my understanding, under the law, you must select a chief deputy that's capable of meeting the same exact requirements as you. This is like a vice president, your second in command. This person must be qualified at the same level as a sheriff. Live in the county, for 2 years at least as a voter, be 25 years old, be a certified peace officer. The same things that Mr. Gilstrap would have to do. He put down a subject, Murray, Murry. Through my research, I was able to find 2 Douglas Murrays. A 24-year-old male, so that lives in Cobb County, cannot be served as chief deputy because he does not meet the requirements as being at least 25 years. The other Douglas, I believe, but this is only known to Mr. Gilstrap, the other Douglas Murray that I could find, I can't find, he lives in Cobb County, but I was able to find through Georgia Post. They're the Georgia Post Council certifies peace officers, or like they keep my licensing and all that kind of stuff, which you would for a medical doctor, do any of that. That Douglas Murray, he's not just suspended, he had his certification revoked by Georgia Peace Officer Standard and Training Council, revoked. So he cannot be a peace officer. They revoked. And in the exhibits, I attached the reasons he was revoked. He was accused of 12 or 13 felonies, and they, instead of prosecuting, it looks like they revoked him from my reading of the reports. So in that regard, if that is, and again, this is for Mr. Gilstrap to answer which Douglas Murray is, because it's too vague for me to determine and the voters to determine actually appointed as chief. One that I found is not old enough, and 2 cannot serve because his certification's been revoked. It's gone. They took it from him. And it's been that way since 2012, and it stands that way right now. That person cannot serve, so he appointed an invalid person to serve as deputy, thus not qualifying under the local laws of Cobb County. I also challenge if this Douglas Murray is in fact a registered voter for at least the last 2 years here in Cobb County, if such person exists. Maybe he's here today, it'd be great to hear from him, but if it is the person that had a certification, 24-year-old, neither of those can serve here in Cobb County. That is just my second challenge.
Thank you.
Addressing the second challenge, we would stipulate that Mr. Murray did have his certification revoked, but for the purpose of what the petitioner alleged, he's alleging, and I know I looked at so it just retained the local law, and there's a local county law that says chief deputy has to meet the same qualifications as the sheriff. However, you're looking at involved in he brought his petition under 1561. That's what he brought it under. If you look at, that's not a local law, that's a general law. Mr. Litchfield will tell you too that if there's any conflict in local laws and the general laws, the local laws are the wayside. So in that regard, if you look at as far as the revocation, you don't even have to be a certified police officer under 1560J. And I've got copies of the code section I'd be happy to share. But it says, specifically what it says is, once you're elected, then you have 6 months to become a certified police officer, once you're elected. And that's what he put in his petition, if you look at it. So that doesn't affect his qualification today. That could be an issue if he's elected, if you ever got that far. But specifically, under the J that he quoted, any person who is not a registered certified peace officer at the time such person assumes the office of sheriff shall be required to complete satisfactorily the requirements for certification as a peace officer as provided in Chapter 8 of Title 35 within 6 months after such person takes office, provided, however, certain extensions can be granted. So you don't even have to have be a peace officer. So that doesn't apply, and even if Murray stayed in, he'd have 6 months, and only if Mr. Gilstrap won the election, to be recertified. So that's not an issue under the challenge that he brought. And the other thing, and Mr. Litchfield, I've got copies of the statute, I'm sure you're familiar. Okay, Georgia Constitution, which trumps everything. Georgia Constitution, Article 9, Section 1, Paragraph 3. A, the clerk of the Supreme Court, judge of the probate court, sheriff, and then it goes into other individuals, tax collectors, tax commissioners, shall be elected by the qualified voters of their respective counties for terms of 4 years, and shall have such qualifications, powers, and duties as provided by the general law. The general law they're referring to is what Mr. Litchfield has in his hands, Title 15:16:1. And I just covered that subsection J. So he's clearly qualified there. And the other thing he brings up is about whether he's a registered voter or not. Again, you have to go back to the general law, not the local law. If you look at 15:16:1, C under qualifications, and then C, 1C. So it's 15:16:1, C1, then B. At the time of qualifying as a candidate for the office of sheriff, he's a registered voter. There's no dispute in his package. He certifies, in this package is his voting certificate. Resident lives in Cobb County, has, and that's in his package. So that's not an issue.
I don't want to interrupt you, but I wasn't referring to I was referring to Mr.
No, I understand that.
Okay.
And I'm getting to
I
the
just
next
want to
one.
make sure.
And the point that I'm covering there, I would ask Mr. Herndon to show me under the laws, the general laws under this code section, where it says the deputy has to meet those same requirements that the Constitution and the general law. He can't answer or respond that there is anything, because there's not. Cobb County was able to pass a local thing that maybe a couple other counties have. But this is the general law. Probably 155 of the other counties in this state, you don't have to certify anything about a chief deputy. It's just only for whatever reason Cobb chose to do that years ago. But we're dealing with the general law here, because if you look at page 4 of his objection, let's see. If you drop down below the italicized paragraph, then you have the second paragraph. He says, as there is a possibility there is another story, he challenges under 15:16:1. And he also goes further and challenges officers under 15:16:1 in the next paragraph. So that's something that he filed, but it doesn't affect application. He's fully because he did it under the general law. And there's nothing as to that has to be submitted.
Okay, Mr. Gilstrap's attorney referred to the portion under section J of the law on page 4 of the written complaint. It talks about whether or not a registered peace officer or certified peace officer within 6 months. He is a registered peace officer. He's registered with Georgia Post as being a peace officer in this state. Certification is revoked. So he's registered. They know who he is. He was once a peace officer. Certification is revoked. So it's not a matter of, this is more for people that have never been a peace officer. If I was to appoint one of y'all and I wanted you to be my chief deputy, I'd have to send you to school within 6 months and get you certified, and you'd have to be able to meet that qualification. In other words, you're not like a felon or something like that. But in this instance, Mr. Murray's already registered state. His just certification is revoked, and he cannot practice as an officer. The other attorney bring up was talking about whether or not he's a registered voter. And it does say that. I'll give you that. It doesn't say where you have to be a registered voter, but part of the qualifications to run for that office right above it is section B that says has been a resident of the county that he or she seeks for the office of sheriff for at least 2 years. So Mr. Murray would have to at least lived in the county 2 years prior to the very date that Mr. Gilstrap qualified. If he did not do so, he also does not meet that standard. That is my argument there.
But simply responding to that, again, he brings a challenge under 15:16:1. And under the code section he brings it on, that being a resident where Mr. Murray lives as to the general, because the code section says, this relates to the sheriff. This code section is for the sheriff. It's got nothing to do with the chief deputy sheriff. So when you look at the qualification for the sheriff, the resident of the county, and there's no dispute, Mr. Gilstrap, not Mr. Murray, is the person that qualified to run for sheriff. He clearly, there's no dispute dispute, he's a resident, has been for years. So he meets the requirement under the law, and as I said on page 15, what he brought the challenge under. So there's nothing there. And I said, I gave you the Constitution where the local law yields to that.
That's when it's in conflict.
Right. But if there's no conflict, but in addition, if there's nothing in the general law as to the chief deputy, then you would follow the general law.
There is no conflict?
There is no
What you're saying,
conflict.
because there's nothing stated.
Clear it up. The reason I refer to 1516.1 is because the bottom line is whoever the chief deputy is has to meet the same qualifications for sheriff as Mr. Gilstrap. This whole, he lives in the county. No, I've never said he doesn't live in the county. Mr. Gilstrap lives in the county. Mr. Certified Peace Officer in the state of Georgia is a peace officer. There's no question on that. If you have, the chief deputy has to meet the same qualifications as sheriff, then those qualifications within 1516.1, that is my point. And if his pick does not meet the qualifications in 1516.1, then he is ineligible on multiple counts. I've yet to hear if Mr. Murray even lives in this county and has lived here for 2 years, attained the age of 25, and is not actually revoked. He is revoked. I heard him stipulate that he's revoked. He cannot be a peace officer under revocation. Just because he's that way, it doesn't mean post give it back to him.
He can certainly petition him.
He can petition, but
So that's,
at the
he's got
time
6
of
months.
qualifying, he would have to petition and go through a process that they may or may not grant. But on that day when he qualified, he was not qualified.
Well, Jay says he's a registered police officer or certified police officer.
It says any person who is not a registered or certified peace officer at the person assumes office. He is a registered peace officer, but my argument is his certification is revoked. It's the same as if you're, somebody says you have to be a lawyer in good standing with the bar to get this particular job, and you're saying, well, I was a lawyer, but I'm disbarred.
Is he registered?
He's registered, but the law doesn't ask if you're not.
Registered or.
The way I'm reading it, sir, any person who is not a certified peace officer at the time the person assumes office, sheriff to complete the requirements for certification. This guy already went through the requirements for certification, so he can't go do that again. He already went through the requirements of certification. He's registered as a peace officer, but they decertified him. They revoked him. So he can't. It's like being disbarred. He cannot be a cop.
And speaking to that, to address it, if you're a lawyer and you're disbarred, you're no longer a lawyer, period. Can't do it. Same thing is, that's why you're post-certified. You're either a certified or registered officer or you're not. That's why it was revoked. So once it's revoked, it's revoked. It's not like I'm still a police officer, but it's revoked. No. Like if you're a medical doctor and your qualifications are pulled for something. You don't go around saying, well, I'm still a medical doctor that I can do. No, he's revoked.
But what I want the board to know is, I mean, we know nothing about this Mr. Murray. Is he a resident of Cobb County?
We don't know, we have not identified that he even exists.
And-
That's right. Part of my challenge is
Is he
does
here
he
today?
exist?
He is not. No, I was going to testify.
Why is he not here?
He had asked him to come. He couldn't get him a right.
Couldn't get him, and then he said he's out of town.
But I can have Mr. Gilstrap just briefly. In your conversation with Mr. Murray, did he say anything to you where he lived?
Yes, he said he was a resident at
At the Queens Mill?
Queens Mill.
And what city is that in?
That's in Mapleton, Georgia.
I'm sorry, Queens what?
Queens Mill.
Queens Mill Road.
In Mapleton, Georgia.
In where, Georgia?
Mapleton.
Mabel.
Right.
I can't hear.
Yeah, I understand.
Is he a registered voter in the state of Georgia?
You don't know? if he
No, I
did
don't
that.
know.
Because I could not find where he's a registered voter.
I think he lives, and it may be his son that's a 24-year-old lives with us.
And that's just hearsay. We don't even have an affidavit from the guy. I thought at least we have an affidavit or a phone call or something. But this,
Do we have a registered voter under that name?
The registered voter, which is the younger Douglas
Right.
Murray, at that address. I took the birth certificate that was submitted by Mr. Gilstrap and used that birth date, and there's no registered voter with that birth date.
so that's another failing under this code section.
I have a
question, if you don't mind.
Yes, sir.
Since there was a confusion about who Mr. Murray is.
Yes, sir.
The young one or the older one or whatever, the one that we're here now, is he the one that was terminated for cause from Cobb County, Stone Mountain, and Morehouse?
No, sir, that was Mr. Gilstrap.
Okay, thank you.
Okay.
Even on the count of being a registered voter, we're talking about in the county, in Cobb County.
The
Or
law
we're talking
says,
about in the
the law
state
says
code?
that you have to, at the time of qualifying, you have to be a registered voter, okay?
Right, period, in Georgia.
All right, well, but the preceding that is they have to be a resident for 2 years. You can't be registered, right,
registered.
in somewhere else. If you're not a, if you're a resident of Georgia, Cobb County for 2 years, you can't be Fulton.
That's right.
And as far as you know, has Mr. Murray, the older Mr. Murray, lived in Cobb County for excess of 2 years?
Yes, boss, I know.
But you don't know if he's a registered voter. That's correct. Okay. And Mr. Litchfield, the other thing I want to address when you talk that laws aren't in conflict, these laws clearly are in conflict, in our opinion. You're relying on the county laws where it says the chief deputy has to have the same qualifications as the sheriff. However, when you go to the general laws, there's no qualification, nothing for a chief deputy. So there's, and that's why I asked him, if he can show me on the general laws, where is there anything about a chief deputy? And there isn't anything, so there's clearly a conflict.
Well, I don't see that as a conflict.
Well, because we're arguing here over the fact that maybe he wants him disqualified because either he was revoked or he's not a registered voter in the county. And the situation is the chief deputy, if you look at the code section, doesn't, where does it say in the statute, general statute 1516(1), anything about a chief deputy and his qualifications? It doesn't.
That's what I'm saying.
Right. So if it doesn't, then the local law doesn't apply.
If it had something about a chief deputy and it said you had to be 21 years old, the local law said you had to be 18 years old, the local law would not stand.
Right, I agree, yeah. But when there's nothing, general law is, and you have the chief deputy in the local law, you gotta look to the general law. And the general law has nothing as far as.
I understand your argument, I just disagree with it.
Okay, okay.
My other point is Mr. Gilstrap made an effort, what he thought was to pick a chief deputy because he went through the same motions as all the other candidates, and he filed the paperwork with the probate court and went down there and had this guy fingerprinted and himself fingerprinted in the whole 9 yards. So it was his intent to select the chief deputy using this same law that every other sheriff's candidate has used in the county since at least 2003. And Mr. Gilstrap has been in the process 4 times before qualifying. So he knew what was required, and he'd been through this process, but he, for whatever reason, didn't do it correctly this time. He did not meet what the statutes require. And even if we get past all, still talking about my first, we hadn't really been addressed, he did not submit the affidavit stating that he graduated from high school, when, where, how, any of that the law calls for in 1516(1). 100%, that paperwork is not there. And I don't see a remedy for that under the law. I do not see any way to overcome that. Like I said before, the clock's run out. The only remedy to that is he is not on the ballot because he did not the affidavit and meet all the requirements.
But
and when you add this,
but in the qualifying documents, he did
somebody at that back window taking pictures.
Sorry?
Somebody at the back window taking pictures.
It's probably the paper.
Okay, I was just making sure you
You're
know.
gonna be on the cover. You and the coronavirus.
The doors
Yeah.
are locked, the doors are locked, you're okay.
My wife's an epidemiologist. I've had enough of hearing about the coronavirus.
He did submit his birth certificate, his high school diploma, which has the name and when he graduated, with the documents.
That's not what I see the law calls for.
Okay, well, I want the board to, at the time he qualified, he gave the Democrat Party a copy of his high school diploma.
And Mr. Herndon is arguing that there is a required affidavit that needs to be submitted in addition to, and an affidavit almost certifying.
The
that this
affidavit
is a
for sheriff,
certifying
the
person.
affidavit for sheriff says, I shall file an affidavit
Yes.
with the election superintendent of the county at the close of business on the third business day following the close of the qualifying period, stating I have attained a high school diploma or its recognized equivalent in educational training, and the graduation date, name of such high school. And he's saying that a third affidavit has to be filed. And I guess the other side of that argument is that an affidavit was filed where prior to that recital, he says, I have obtained a high school diploma. Okay, so he's swearing that he's obtained it. And he has filed his high school diploma showing the date we graduated and the name of the high school. So he's fulfilled the intent of the law.
Which is to prove that.
He has a high school diploma. So, you know, the argument could also be made that this affidavit for sheriff isn't, and it was filed with the Board of Election by the Democrat Party, is sufficient to, because it included the high school diploma. Or you can take the argument that there should be a third affidavit.
And it did include, the packet did include.
It does.
In this case, it did include, it wasn't an affidavit.
No.
Certainly an agreement.
They actually submitted the original to us, so it's been in our custody. Anything else?
Yeah, I've just got Mr. Gilstrap. I wanted him to testify.
Okay. You can remain seated.
Okay.
Can you raise your right hand, state your name,
Gregory Gilstrap.
and do you swear that the testimony you'll give in this hearing shall be the truth and nothing but the truth, so help you God? Okay.
And you're Gregory Gilstrap, running for sheriff? Okay. And you've seen briefly the qualifying papers that have been stipulated to. You fill those out?
That's correct.
You provide to the Democratic Committee?
Yes.
Notarized?
Yes.
And at the time you did that, was there 2 affidavits
Yes.
submitted? And I'm going to hand you what's been marked as Gilstrap 1. Mr. Litchfield, may I approach?
Yeah, sure.
And I've got copies of the board members.
And
I'm
we have this.
I'm just going to, just a
They all have
synopsis.
copies of it.
Yeah, okay. And Mr. Gilstrap, that Exhibit 1, that includes, is that correct?
Which one are you talking about, the affidavit for sheriff or the other one?
The other one.
Okay,
There's a copy of
okay,
it.
thank you.
When you filed your paper with the committee, you submitted all those documents, is that correct?
That's correct.
But they were different orders, is that correct?
Yes.
And how many pages is that? Well, it's 5 pages,
5 pages.
and they're all dated 2nd, 2020, correct? All timed at 11 o'clock a.m.
Correct.
You meant it to be filed as a package, is that correct? And in that package, your affidavit that you meet all the qualifications for sheriff, it's designated Murray, okay? And then you had a separate letter, and that was all notarized by the Democratic Committee, Mr. Southwell.
Yes.
Then you had a separate letter that he, part of your affidavit, is that correct? An exhibit, witnessed by Mr. Southwell. Yes. Okay. Stamped in at the same affidavit, correct? And it talks about certified and certified diploma, is that correct?
That's correct.
And attached to that, you have certified birth certificate, is that correct?
That's correct.
And you have certified copy of your high school diploma, is that correct?
That's correct.
And your high school diploma specifically states that you graduated on June the 2nd, 1980, is that correct?
That's correct.
Okay. And that was all true and correct at the time you did it? And that was in the qualifying period?
Yes.
And that's all part of your package?
That's correct.
Okay. I think that's all I have as far as that. Do you have any questions for me?
Sure. Just to touch on this, I don't want to divorce, but Mr. Gilstrap, on your first form here, affidavit we're looking at, was anywhere on there, does it say when and where you graduated from high school, or the code section? say when and where, or if you obtained equivalency in education?
Yes, we got the form on here. Year and school, where would I attend high school from?
On your affidavit. I'm asking on this form that we're looking at, just this piece of paper, does it say on here when and where you graduated from high school? And if you graduated from high school? That's all I'm asking.
Because as far as the members are aware, affidavits can have exhibits and attachments are all encompassed and included in the affidavit. That's what he did. That's why it's all put together like that package. But all those documents are kind of were submitted. It's all part of the same affidavit.
I understand your argument.
Okay. That's like saying Exhibit B to an affidavit isn't really part of the affidavit.
I didn't view it that way, but it's okay. But yeah, that's I just don't think he met the requirement of filling out that specific affidavit and then issue with the chief deputy. Unless we need to go round and around some more, that's my points on that. That's it.
Okay.
And obviously, if people have questions.
Does the board have questions? Do y'all have to add?
Yeah, let me just ask you, we may not be able to have to call these other witnesses. Yeah, we don't have to call the other witnesses.
I don't see any reason to either.
Okay.
I'd
Thank
like to
you.
have a quick question. What were the witnesses going to testify to anyway between these two chapters?
What that how they were appointed and they're certified by the Democratic Party of Georgia. They take in, just kind of like the prior witnesses, they take in all the paperwork and they submit it. That you don't go separately and file affidavits with the election board. You do it through the committee.
No.
And they submitted all that to the committee. Because I think Mr. Herndon was saying, no, that's not good enough. You can file affidavits, but you've got to take a separate one of those affidavits down to the election board.
That's not what I said, actually.
So, okay.
I said it had to be that specific affidavit. And I mean, we do need to call them, because when I asked them, they said, no, you can take that one down there to the board. And that's what I did, because Matt Southwell also, my affidavit certifying when and where I went to high school, we have that here if you want to see it. I actually got Matt Southwell at that time to certify that affidavit, which the Democratic Party took a copy of, handed it back to me, and I went and filed it with the election superintendent, because that is what the law told me to do.
Should have done that? Go on.
Yeah, he didn't even have an affidavit saying
And we'll
that.
have to call them, because my understanding, what they'll testify to is you do not have to do that if you go through the Republican or the Democrat.
Mr. Herndon, you do not have to. It just has to be notarized and sworn before an officer of the party that is qualifying. It doesn't mean that that officer has to sign anywhere. There's no provision in any of the Republican or Democrat forms that has that officer sign.
I still obviously argue the point that that affidavit actually saying that he graduated from high school and met those qualifications.
I understand.
Doesn't exist.
I understand.
The main crux of this, without getting lost on all the other.
Okay. And I'm fine with what you said, Mr. Litchfield, as far as the party there.
All right, so
More than I have in my phone stating that a text, when I sent a text to Mr. Murray, confirming his address.
Can you speak up, please? We're over here.
Okay, I'm sorry. I have in my telephone a text from Mr. Murray indicating his residence in Cobb County.
Testify.
Yes.
I think that's all we have.
okay. So at this point, Phil, we need to go into executive session to discuss.
All right.
And then we'll need a motion to go into executive session. Y'all will have to exit, and then we'll recall y'all back in, and then we will hopefully have a ruling.
I move that we go into executive session.
I'll second that.
All right, all in favor, please raise your hand. Okay, we're in executive session.
Okay, you promised me. I gotta We need a motion to come out of executive session.
Yes. I hereby make a motion that we come out of executive session. We have a second.
Second.
Have a second. All in favor, raise your hand. Back in regular session now. And,
You can entertain a motion
and
on the
we'll now-
challenge.
We'll now have a motion concerning the challenge made in the case of
I make a motion as a result of candidate Gilstrap's failure to comply with the laws as specified for registering as a candidate, that he be qualified to run
Specifically,
because of the failure to abide by the law,
which law?
filing the affidavit, third affidavit. And if that's not for deputy,
is there going to be a second, or do we have another motion?
Can we amend that one?
You can.
We can
Well, we'd
amend
have to,
that
you could have, yes, you
We
can.
well,
Or you can make a substitute motion.
substitute.
You can amend it.
Well, it doesn't have a second, so it's not a motion to be amended. But you could make a substitute motion. Second it, and you can amend it.
Fail to have a second.
Yeah.
I would like to move that we deny Mr. Gilstrap's certification. Is that correct way to
Or
say it?
you're making a motion to disqualify him as a candidate?
Right, to disqualify Mr. Gilstrap as a candidate because the person that he is a chief deputy does not meet the qualifications of the sheriff.
I'll second that.
Second. We have further discussion. All right, all in favor, please raise your hand. All right,
Thank you.
well, thank you.
Thank you.
And that's
And
based on
You
Murray?
do have 10 days to appeal.
The Murray situation?
Yes.
Right.
And I'd like to order a transcript.
We don't have a court reporter. You could have brought a court reporter.
Well, they said it would be video, when I checked, they said it
Well,
would be
then-
videotaped and it would be, that would be a
Is that
sufficient
available?
record.
I assume it.
It's going to be able to.
Oh, you can save it on YouTube.
Yeah, it'll be on YouTube.
Okay. Okay, we stipulate that's a record, because when I inquired, they said it was gonna be recorded and everything, that would be a record.
I'm sorry?
Those guys are recording.
Yeah.
What is that?
They're recording it.
Okay,
You can get a copy of that.
is that,
Cobb County.
okay. What department is that?
Communications.
Okay. And I guess it'd be interesting with the 10 days based on Chief Justice Melton's order.
Yeah, we'll see.
Yeah. Okay. Thank you.
All right, thank you.
Thank you.
Okay.
Do we need to take a break?
I'd like to.
Yeah, me too.
Yes, I am Phil Daniel, Chairman of the Cobb County Board of Elections. I'd like to, for the other board members to introduce.
Fred Aiken, Vice Chairman.
Darrell Wilson Jr., Commissioner appointee.
Jessica Secretary.
Mira Ball, B-A-H-L, Assistant Secretary.
My name is Greg Litchfield. I am the board attorney. And the rules of this hearing are that Mr. Herndon, the challenger, will present his case, and he has the right to call evidence, or call witnesses and introduce evidence. And the candidate being challenged, Mr. Owens, has a right to respond, present his case, and present evidence and call witnesses. I would like to try and keep it as succinct because of the timing, but I would also let you know that we're as long as possible, and we can begin.
Good afternoon, board. My name is James Herndon, H-E-R-N-D-O-N. I am the challenger. My first challenge in reference to Mr. Owens is things the board has already heard today. It is in reference compliance with OCGA 1516-1C3, and that examining Owens' paperwork, I did not find any affidavit stating when, where, or if he graduated from high school. And this particular case, you may have seen earlier, there is no diploma attached, there is no supplemental documentation, there just is no documentation as to any attempt at complying with the code section. There is no affidavit saying when and where, if he went to high school. The question for the board is not if he's a graduate, he comply with the law under this affidavit. Along with the law 1516 that says you must submit this affidavit within 3 days after qualifying, which would have been March 11th by the close of business. He also filled out on his affidavit, when you view it at the bottom, it'll state that I shall file an affidavit with the actual code section says I shall file an affidavit with the election superintendent of the county by the close of business on the 3rd business day following the close of qualification period, stating I have attained a diploma or its recognized equivalent in training as established by the Georgia Peace Officer Standard and Training Council, and graduation date and high school or obtain such recognized equivalent training. In addition, I will also file a certified copy of my birth certificate to the election superintendent. Owens did file a certified copy of his birth certificate with the Board of Elections, but he did not submit any documents in compliance with that code section. Did he graduate from high school? Is there an affidavit saying he graduated from high school? Did he submit a diploma that he graduated? None of that I could find within the paperwork that I obtained from the Board of Elections through open records requests. Going to that, I mean, under 1516.1, the General Assembly made it clear they want people to follow qualifications. They say it's declared to be the intent of the General Assembly that proper qualifications and standards be required of the person holding office. And as such, each qualification, no matter the printing part, can't be a felon, got to be a certain age, got to live in the county, got to do this affidavit. No one qualification takes precedence over the other. You either got to meet all the qualifications or you don't. It's just spelled out in the law, and as we know, the General Assembly puts the law out there to be followed. It was Owens' duty and his alone as the candidate when he submitted paperwork to know and read the paperwork he was signing. Not only did he have the law telling him he had to complete his affidavit, he completed an affidavit on the day of qualifying that said he would in fact comply in his own hand, his own sworn statement, that he would comply and turn this affidavit in 3 days to the election superintendent. To my knowledge, to this date, he still has not done so. Past the time of qualifying, the bell can't be unrung, time's run out on that. The official code of Georgia also states, OCGA 136, after they take effect, the laws of this state are obligatory upon all the inhabitants thereof, and ignorance of the law excuses no one. So you can't just use, I didn't know, I forgot. That's not an excuse to disobey the law. In this case, he didn't submit the affidavit saying he had high school, even an attempt. It's a paper like a certified, like we've had other candidates where, you know, you submitted a copy of your high school diploma, any of that. We don't have any of that here, nothing. So I'm not arguing whether or not he graduated from high school. I'm arguing whether or not he actually complied with the law and turned in this affidavit, demonstrated and followed the law. And in this case, it doesn't appear that he did. And as you have the written complaints, which is much more detailed, I have there, and the actual complaint, very complaints, which I'm sure I don't need to go over again. But that is for my first challenge, and if they stop there and handle the first challenge from there before we go into the second, then I'll.
For the purposes of time, good afternoon, ladies and gentlemen. My name is Cindy Yeager, and I'm an attorney, local attorney here in Marietta, and I'm representing Mr. Owens. For the purposes of time and applicable based from the Georgia Supreme Court, I would say that if you did challenge 1 and challenge 2 in sync with one another, the evidence presented will go to both those challenges, and the appropriate to those issues would apply to both, and so it might be easier to do those together. So if you want to present your second challenge this time also.
That's fine.
My second challenge is to Mr. Owens' qualifications. That Craig Owens admitted information in his affidavit that he did not fill it out lawfully, truthfully, which is a violation of the code section of qualifications in 1561. By submitting the documents to this board and is thereby possibly a felony under Georgia law under 161071, the offense of false swearing, because this document is sworn and attested to and signed by candidate Owens. On the form affidavit for sheriff, which is Exhibit A attached to my written complaint, on my written challenge under Section I, listed is a complete written history of my places of employment period of 6 years immediately preceding my qualification date, giving the period of time employed and the name and address of my employer. As evidenced by that affidavit submitted by Owens, he only listed one entity on there, Cobb County Police. He doesn't list the period of time that he was employed. He doesn't list the employer. Those are clerical things. I can look over those, to be honest. Those are things, we got Cobb County Police down there. So I don't have to be that technical on that. We can say that's a clerical error. But it is a requirement under the code section they do so. But more troubling is that Craig Owens has in fact worked for other employers over the years, over the 6-year window that we're looking at. And he has a sworn affidavit as per OCGA 1561. The affidavit specifically stated he was submitting on the affidavit a complete written history of my place of employment. Again, at the bottom of the form it states, with lines beneath it, complete, quote, history for previous 6 years. That is in the code section that is required for sheriff. Attached to my written complaint, I find 40 pages of documents from the Department of the Army showing that he did in fact have another job, at least with the Army. I thank him for his service, that's nice, but it was not listed on the form that's required. But even if we were to overlook that he somehow forgot that he was in the U.S. Army Reserve, I also obtained 17 additional documents from Cobb County government yesterday through open records. With county government shut down with this COVID-19 crisis we're going through, getting records has been very hard. I have Chief Cox from the Cobb Department waiting in the lobby to testify to verify some documents I'm going to present to this board. But I was able to find out in a limited time because clerks that actually pull this information for Cobb County Police Department are not available to pull all of the records I'm seeking until Friday morning tomorrow. But in the interim, they were able to give me the last 36 months, which shows he worked at 7 different employers that he did not list on his application or his qualification for sheriff. These include the Monticello Nightclub, the Home Depot, Atlanta Country Club, North by Northwest Office Park, Synovus Bank, Foot Locker, and then a Army Reserve. So Owens did not list at least 7 known employers. I'm sure they have to be known to him. He works there. On his, and that's just going back 3 years. It may be worse, it may be the same. I don't know until I get the rest of those records. But what I've got right now is that he worked at 7 other employers. He did not disclose that. He did not put that on his form. And it is a form he swore and attested to that was his complete places he had worked, and he turned that in. That form was by Matt Southwell when he was qualified. Then that form was further given to the Board of Elections, and that's where the whole issue is, if it is a felony or not. I'm not that part. I'm here because he didn't put his places of employment on the form. Those were not mere clerical errors. Owens knowingly did not disclose all the places he had been employed over the past 6 years. He submitted a sworn affidavit that was less than truthful in his affidavit. The lack of following Georgia law procedures cannot be overlooked by this board. The affidavit has already been submitted under law that allows Owens to go back in time and reset the clock and just do this form over even if he wanted to. And to my knowledge, he's not trying to amend it or fix it. He's just left it stand. Owens, qualifier for the office of sheriff, failed to meet the standards prescribed by law in the time frame prescribed by law in the manner the law dictates. Again, I believe the question before this board is, did Craig Owens list all places of employment for the past 6 years as prescribed by Georgia law to qualify for the office of sheriff? I believe that answer is no. He did not. Again, the General Assembly enacted these requirements of the office of sheriff, and 1516.1 states, it's declared that the intent of the General Assembly that proper qualifications and standards be required of the person holding the office of sheriff. Each qualification in Georgia law is equally important, one not taking precedent, that all qualifications must be met to run as the chief law enforcement officer of Cobb County. Again, it was Owens' duty, his duty alone as the candidate, no other person handling paperwork, to submit the required documents as per Georgia law and in the format and deadline dictated by Georgia law. To ignore this qualification would set, I believe, a dangerous precedent for future elections. It will allow future candidates to also not meet requirements and qualifications of their choosings. No one qualification, again, takes precedence over any other. All the qualifications prescribed by Georgia law is paramount to seek an office that is the chief law county. Again, the official code of Georgia states, 6, after they take effect, the laws of this state are obligatory upon all inhabitants thereof. Ignorance of the law excuses no one. As you know, qualified closed. Owens did not meet the qualifications to be on the ballot for the office of sheriff as prescribed by law. He did not submit the affidavit as prescribed by Georgia law stating the name, address, time for all of his employers over the past 6 years. He did not follow Georgia law to qualify for the office of sheriff, and as such should be disqualified and have his name on the ballot. That's the end of challenge 2.
Can I give a brief opening?
Sure.
Would that be okay?
Sure.
And then if Mr. Evans on that. Ladies and gentlemen, over the past few days, I've done some significant research on the challenges to qualifications of candidates in the state of Georgia. And what we have before you is not unknown to the sheriff's race in particular, because most of these cases actually deal with qualifying for sheriffs. I would submit to you that based on the research that I've done, qualifications for sheriffs is a lot of paperwork, as you've heard. The actual issue before you is not the challenge on the paperwork. What's the actual challenge based on the case law from the Georgia Supreme Court is the candidate qualified to run for that position? We're going to submit to you today that Mr. Owens is more than qualified to run as a candidate for sheriff, that the Democratic Party looked at his documents, spoke to him, signed the candidacy themselves, reviewed his paperwork, and certified them that he is qualified as a candidate for sheriff of this county. We are going to ask that Ms. Bettapour be put on the phone so that we can question her in a few minutes, and then I believe Mr. Herman's going to call Mr. Chief Cox from the Cobb County Police Department, which we've asked him to be here also, so we can assert to those questions. I will also submit to this panel that based on some of the research I've done, in particular, I won't go into closing, but that I would like to point out that 2 specific cases that the challenge, minor accuracies do not disqualify somebody from running for office, and that the qualifications of a person, the date at which the person must be qualified, is really the date of the election. So just as you talked about in these prior hearings, just as an officer can be certified post-mandated before or after the actual date of the election. It is the date of the election that monitors when a person has to be qualified for. In some cases that we don't have this situation are where people have actually committed felonies, they're looking for a pardon so they can run for sheriff. If you get a pardon before you run for sheriff, you can run, but if you're in the process and then you get elected and you're not pardoned after, you're disqualified. Some of the key dates that we're going to have to be looking at, because the issue before you, this board today, is not necessarily the accuracy of the paperwork, but it's the question. Did Ms. Betancourt, when she certified Mr. Owens at the time that he stood in the Democratic office and submitted his original birth certificate and submitted his documents, and she notarized one and she reviewed the other one he notarized, and he paid the qualifying fee, did she accept him as an appropriate sheriff candidate, qualified, based on the qualifications stated in OCGA 1615-1? And 1516-1? And I think the evidence is going to show you that she did, that he is in fact qualified, and that he should be allowed based on the first two challenges should be dismissed. The rest of the case law, because I don't want to repeat myself, because I know you've been here a long time, I'm going to end after you've heard the evidence so I can kind of put the pieces together.
If I can go ahead, we can go ahead, Coxon, go ahead and skip to this and get him on his way, and that way I can get the document showing that Craig Owens works.
Can you state your name for the record?
Charles Timothy Cox.
Okay, can you raise your right hand? Do you swear that the testimony you give in this hearing is the truth, so help you God?
I do.
You may sit down.
Thank you. Chief Cox, James Herndon, I'm here as soon as possible. My basic question to you is for me to certify these documents and submit them to this board, you to verify that these are documents of Craig Owens' employment through the Cobb County Police Department that you guys have on record. This is just 6 months, so I wasn't able to get the full 6 years yet because of the quarantine.
These are copies of secondary employment request for Major Owens to be within policy of the police department. If he should request or seek second employment, whether he received that employment or not, I have no idea.
Yes, sir. But to your knowledge, these are jobs that he requested for other employers.
Those are secondary employment requests that were submitted to the
And
police department.
if some of them were renewals, that would indicate that he had been working there previously.
It would not indicate that to me. It would indicate that he had the ability to pursue that employment if he chose consecutive years. But whether he worked in any of those jobs, I do not know.
Yes, sir. Can I submit these in now, sir?
Yes, no objection. Chief Cox, how are you?
Doing well, how are you?
And Chief Cox, you know Major,
Yes, ma'am.
and you are his supervisor.
Yes, ma'am.
And as the chief of police, you know what qualifications he has to be a Cobb County police officer?
Yes, ma'am.
And are you aware if he graduated high school?
I have seen a diploma from high school in Atlanta, Georgia that indicates he has graduated.
And can you look and tell us the name of that high school?
West Fulton High School.
And what year did you graduate?
I believe it was 1984.
And he has a bachelor's degree from Leo University?
Yes, ma'am.
And what year did he get that?
2006.
And he has a master's degree from?
Yes, ma'am.
I forget where does he have his master's degree from?
It was Columbus State University,
And where did he get?
2011.
And Mr. Owens has been a Cobb County police officer since 1989, is that correct?
That sounds correct. I don't have his exact date of employment with me, but that sounds correct.
And being a Cobb County police officer during the entire period, which is over 30 years of service now, during all that time, he has been a post-certified officer for the Cobb County and the state of Georgia.
Yes, ma'am.
And when we talk about these part-time jobs, officers normally go to the Cobb County Police Office Department to get the part-time allowance, because if they get approved by the county, then they're allowed to do the part-time job in uniform,
Yes, ma'am.
and they're allowed to do the part-time job using their marked patrol car
Yes, ma'am.
or their unmarked patrol cars if they're on some kind of stakeout.
Under certain circumstances, we would allow an unmarked patrol car.
And at the entire time that they may be working a job at an agency, they still are a county police officer, correct?
Yes, ma'am.
They still maintain all their arrest powers?
Yes, ma'am.
And frankly, a police officer is a police officer 24 hours a day. Is that not true?
Yes, ma'am.
24 hours a day, 365 days a year.
Yes, ma'am.
You're basically never off duty.
Yes, ma'am. And my wife would attest to that.
And so, Cox, even though that his specific part-times are not listed as part of employment as a Cobb County Police Department, he is actually using Cobb County Police services, cars, uniforms, guns, all of which have been supplied by the Cobb County Police Department for the purposes of those part-times.
Anybody that submits a request to do a part-time employment through our department would be, yes, ma'am, would be allowed to use representation as a Cobb County police officer in their vehicle to perform that job.
And Chief Cox, you also know that Major Owens has a significant history in the armed forces,
Yes, ma'am.
and he is a member of their reserves. Was a member of their
Yes, ma'am.
reserves, and he has since retired from that post.
That is my understanding.
But that is a part-time. I mean, do you consider that a part-time job, or what do you consider that?
Under the policies of the Cobb County Police Department, we do not require the officers to submit a employment request for their military duty or reserve duties.
And Major Owens, I think, served probably over 30 years as an Army reservist. Isn't that correct?
It was a significant amount of time.
And Chief Cox, the address of the Cobb County Police Department is 140 North Marietta Parkway, Marietta, Georgia. That's police headquarters.
Yes, ma'am.
And so that's the location of the headquarters of the police department. Is that correct?
Yes, ma'am.
But in fact, in Cobb County, his place of employment is really anywhere in the county. Isn't that true?
He could be assigned to a different location, a different precinct, or a different reporting location.
And at present, Major Owens is assigned to Precinct 2, which is basically South Cobb County.
Yes, ma'am.
And is he subject to any other department, any other agency at any particular time?
He's subject to being moved to any other unit or any other precinct at any time.
That's all the questions I have for Chief Cox.
Chief Cox, the Cobb County Police Department, the key word there, your Department of Cobb County Government, correct?
Yes, ma'am. I mean, yes, sir.
And the address of Cobb County Government is 100 Cherokee Street, your knowledge, correct?
Yes, sir.
Okay, so it's the department thereof. If you consider the U.S. Army, you consider that another employment if a person worked there?
quite honestly, in my 35 years with the department, I never even thought of it as a job. I considered it more of a service.
Employment is what I mean. You're getting paid for it.
I assume they are getting paid for. I did not serve in the military, but I assume they are, from my understanding.
If I was one of your officers and I filled out a part-time request, I'm literally asking for employment with Home Depot, would you consider me being an employee of Home Depot? Under the county policy, don't you guys require them to have workman's comp through that employer?
To answer your first question, if you were submitting a part-time job request under the policy of the police department, I do not necessarily consider you an employee of that business. You're asking permission to obtain employment from a business, and if we approve that employment, we cannot give that approval, but it doesn't necessarily mean that you're an employee of the business. It's, like I said earlier, I don't know if he's employed by those businesses or not.
If an officer is employed in a part-time job or any other capacity, are they required to have workman's comp insurance through that other employer?
Yes, sir.
So that would make them of that employer if they're working there. They're covered by workman's comp.
I'm not an HR specialist, but I understand where you're going.
But as the chief, if you had an officer get injured on the job and found out they were and they did not have workman's comp, they would be in violation of policy.
If they were employed for someplace else, they'd be required to be covered under workers' comp for that other employee.
Right. Because they're working for them, that's the only way to do that under the law. That's all.
Can Chief Cox leave?
If he could, copies, Chief Cox, of his diplomas,
Yes, ma'am.
and I'll submit these to the board with no objection.
Attorney Yeager, could you remind us of whether those were submitted?
Those were not submitted with the initial documents, no ma'am.
And they were not submitted within the 3 days for some of the other affidavit submissions?
They were not submitted within the 3 days, no ma'am.
So this is the first submission?
This is the first submission, yes ma'am.
Chief Cox, you are dismissed.
Thank you.
Thank you.
Thank you, sir.
We would like to call Ms. Betty.
She's not here, I have to call her.
Oh, that's right, that's right. No call.
Everybody run. Getting everybody to be able to hear.
Jacqueline? Yes. This is Janine, you're on with the group. Okay. Okay, just hang on a second.
No, I mean about your third challenge, because once she notarized one and somebody else notarized the other.
We can bring that up when we're talking to her.
Okay. I don't know, so I'm sure she told me. I'm guessing, it's a little, first time I've ever done this, but Ms. Bettaport, hello, this is Cindy Yeager. I'm from Mr. Owens. Good afternoon, can you hear me okay?
Yes, I can.
Can you state your name, please?
My name is Jacqueline Bettaport.
Okay, I don't know how to do this, but can you raise your right hand? Do you swear that the testimony you're giving this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Herndon, do you know her?
I do.
Okay.
I recognize her voice.
Okay, thank you.
Okay, and Ms. Bettaport, am I pronouncing your last name correctly?
It's
Bettaport. Can I just call you Jacqueline?
Yes, you can call me Jack.
Jackie, great. Jackie, and can you tell the board what is your position in the Democratic Party?
The chair of the
And how long have you been the chair?
Since April 11th, 2019.
And as part of your duties and responsibilities as the chair of the Democratic Committee, do you qualify certain candidates to run in elections?
Yes.
And what, do you get a list of requirements that you give to the candidates to show that this is what they need to be qualified? Do you recall if you gave a list of those documents to Mr. Owens?
Yes, I did.
Okay, I can't show you the document, but I'm going to read you part of it. And so if you could verify if you believe this is the document that you gave to Mr. Owens when explaining to him how to qualify for sheriff with the Democratic Party, okay?
Okay.
Okay, the top of it is in bold letters, party qualifying information, and it's underlined. And then number 1 is partisan primary qualifiers file the declaration of candidacy and affidavit form. Do not accept a notice of candidates form. They can bring their forms pre-filled and notarized or fill it out there, or you can notarize it in your office. And do you recognize the wording of that piece of paper?
Yes.
And it is numbered 1 through 8. And on the bottom it says revised 2/25/2020.
Correct.
And based, without reading the entirety of the document, this is the document that you gave to the candidates, particularly Mr. Owens, who wanted to be a candidate for sheriff in this election cycle.
I don't find it in that actual document.
Is that the document in the regular course of acting as chair that you would give to a potential candidate?
Yes, so that was given to me by Janine Edler at the Cobb County Board of Elections when I picked up the qualifying packets on February 26th, I believe.
And so you may or may not have given this to Mr. Owens. You probably did.
Yes. What I did is I sent emails to all the candidates in Cobb County with links to the forms that they would need to fill out to qualify for office. I could find that email. I won't do that now unless you'd like me to.
Well, I'll just ask.
To help you, it's
I don't recall
it's
that
different from what you're saying.
document that you're looking at now was attached to that email.
Okay. So, but as far as you can tell, this would be the document on the website that they could get the link to get it.
Yes, so the email I sent out would have had a link to the declaration and candidacy and affidavit form, and it would have had a link to the special affidavit for sheriff that needs to be filed.
Okay, and I'm going to submit this into evidence to the board. 1 second, Jackie.
Not trying to be whatever, but I kind of want to object to something that someone may or may not, she doesn't know if she gave that to Owens or not, but yet we want to put it into evidence. I have an objection based on authenticate whether or not it was given to
I
Owens.
think she's
Based off of her testimony.
I think she's testified that this is the form that was attached to the link that she sent out to every candidate, so every candidate would have been able to secure this particular document to show them how and what did they need to bring to file for their candidacy in that particular Democratic Party. Purposes of this document.
I disagree because I'm looking at the email that I received.
With your objection.
Jackie, I'm just giving the board a copy of the paper that was attached to the link over objection to Mr. Herndon. Now, Jackie, you were in fact the worker or the worker or the officer of the Democratic Committee that was in fact in the office when Mr. Owens came to qualify as a candidate for sheriff, were you not?
Yes, I was.
And you had the opportunity to review all the documents that he gave him, correct?
Correct.
In fact, one of the documents, the declaration of candidacy, he had notarized elsewhere but you didn't feel it was complete, so you had him actually do another one, and you in fact notarized it as an officer of the Democratic Committee as well as a notary public, is that?
That's correct.
And you reviewed documents that Mr. Owens presented, and you believed he was qualified under the code section, I'm going to say 1516.1, to be a candidate for Cobb County Sheriff, is that correct?
That's not.
What, so explain that a little bit.
So I was instructed that in order to qualify candidates, I had to collect the candidate declaration and affidavit form and the sheriff's affidavit form. And that was all I had to do. There were a number of affidavits that needed to be that I had no knowledge of. Being the affidavit where they named the deputy chief. So that was not something I was told that I needed to collect. And I'm not a lawyer, I'm not an attorney, and I was not aware of that qualification. So we did, I put the question before with respect to that qualification, and was told that we were just to accept what the candidate presented, and it was up to the candidate to be aware of the various laws and to seek legal counsel if necessary. So I can attest to is that the candidate declaration and affidavit was filed, and that the sheriff's affidavit was filed with me. As far as fingerprinting and background checks, those were all filed through the probate court. Maybe the chief deputy, I was not aware of that requirement.
But you've not heard any contesting that Mr. Owens did not in fact file his letter requesting the probate judge do an order to have his fingerprints or submitting, and that's not really an issue at here today because that wasn't your job.
Right. So when you asked me if it was me who reviewed all of his qualifications and determined that he qualified to run for sheriff, I can't say that I can make that statement.
I'm asking you that question not with regard to anything that the probate judge or the fingerprinting, what the statutory requirements would be in that code section for the naming of the deputy and for the naming that he had fulfilled all the qualifications to be. I'm asking you the questions, particularly in your review of the documents that he presented. In your opinion, did he meet the requirements as a candidate for the sheriff of County?
With the documents he presented to me, yes.
That he was a high school graduate?
I had no proof of that. I assumed he was, but I did not presume he
And
said that he was on the affidavit, on the sheriff's affidavit.
so he submitted the notarized affidavit saying that he was in fact a high school graduate.
That's the sheriff's affidavit, yes.
And you had no reason not to believe that he was a high school graduate.
Exactly.
In fact, you know that he's a major in the Cobb County Police Department.
Right.
And you're aware that Cobb County police officers have to be post-certified.
Yes.
And so you know that he was post-certified at the time he was standing before you to be a candidate for the sheriff of Cobb County.
Yes.
Did you review any documents with regard to any type of places of employment?
No.
Or the addresses?
No.
Do you recall having any other discussion with Mr. Owens at the time as a candidate for the sheriff of Cobb County that we haven't discussed today?
No.
I believe that's all my questions for Ms. Bettaport this time, Jim. Or Jackie. I'm saying your last name wrong.
Hey, Jackie, this is Jimmy. I'm gonna try to make this short. So, would it be safe to say that in your capacity, as the person taking the qualifying paperwork, that your job was to simply help them obtain a notary stamp and receive the fee and pass it along?
Was to accept the candidate declaration and affidavit form. It was filled out and notarize it if it had not been notarized. And then or that the sheriff's affidavit was filled out and signed and notarized as well.
But in no way can you attest to the truthfulness or accuracy of what a candidate would put down on the form. Like, you would have no way, if I put down I was the CEO of Walmart, you would have no idea of knowing whether or not I was selling or I was leaving jobs off the form.
I would have no idea.
And copy of a high school diploma or anything, as you said earlier, you could only assume as to the educational level of a person, correct?
Correct.
And lastly, you're not able to give legal advice and tell people what they need to do on the affidavit.
Correct.
So it is the candidate's responsibility and the candidate alone to follow what the form and the affidavit says to do.
That's what I believe, yes, but again, I'm not an attorney.
Yes, ma'am. Yeah, yes, ma'am. I know you're not. When someone files an affidavit in any of the offices, and there's direction upon the affidavit or requirements in the law, is it typical for you to tell the candidate everything they need to do?
No, as I just, there were many things that the candidate had to do that I was not aware of.
Yes, ma'am. So if turned in an affidavit, for example, if a candidate turned in an affidavit to you and it had a requirement on there to turn in an affidavit to the election superintendent that that candidate graduated from high school within, you would expect the candidate to perform that duty. That's not upon you, correct?
Correct.
I don't have any further questions.
I just have a couple more questions. And this is with regard specifically to challenge number 3 that we really haven't gotten into, but since Jackie's on the phone, I think let's just cover it now since we have her on the phone. Okay, Jackie, Cindy Yeager again, just a couple more questions. Do you recall that the affidavit for sheriff was signed not by an officer of the Democratic Committee, but in fact a notary? Is that
Correct.
and that is in compliance with the rules for submitting an affidavit to the committee?
Yes, the instruction sheet that you were speaking of earlier said that the candidate could present those forms filled out already at some other time or location, that they could present those forms to us and we could accept them.
So if Mr. Herndon's arguing that that's not correct, that that has to be done by an officer of the Democratic Committee, is that a variance in the way the statute is interpreted and the Board of Elections is interpreting that statute?
I was told that it did not have to be notarized. It did not have to be an officer in the Democratic Party doing the notarized.
I think we've already made it clear that the notary doesn't have to be the officer.
Okay. But in fact, you were the notary on the Declaration of Candidacy.
Correct. That's, did bring a form with him that had already been filled out and notarized, the same notary sheriff's affidavit. But I
Your Honor,
think there was a problem.
It helps just dismiss this third one and stick with the 2 challenges.
Yeah, because we
On
know you.
previous years.
Okay, Jackie, I don't mean to interrupt you, but Mr. Herndon's dismissing charge number 3, so we don't need to talk about it anymore.
But
Okay. Okay.
I have a board member who may want to ask a question.
That answered my question.
Oh, it did? Okay.
Okay, I think, Jackie, that's all my questions. Mr. Herndon, is that all your questions?
Yes, ma'am, it is.
Thank you so much, Jackie.
I did it.
I'll let you.
Want me to sanitize it?
No, I'll do summation whenever we're ready for that.
Let me, can I have a moment outside to
Sure.
sit with my client?
Sure.
Mr. Owens would like to testify on, are you forward?
Okay. Can you state your name, please?
Craig Owens.
Okay. Raise your right hand. Do you swear that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
And Mr. Owens, would you please state your name for the clerk?
Complete name, Craig Daniel Owens Sr.
And you're a major in the Cobb County Police Department. And currently you are seeking to be a candidate for the sheriff of Cobb County and the May 19th, 220 primary.
That's correct.
And can we stipulate to the high school, college, Mr. Herndon? Do we need to go over that again, or are we good with that?
I have no idea. You submitted what you submitted in evidence. I don't know what.
Well, I mean, we're either going to ask him about it or we'll stipulate to it, whichever one you prefer.
Well, just
Okay.
one
Well, I
question.
was just I'm trying to be succinct. Are you a high school graduate?
I am.
And where did you go to high school?
Westwood High School in Atlanta, Georgia,
And what year did you graduate?
1984.
And are you a college graduate?
I am.
And where did you graduate from college?
Master's degree at Columbia State University.
And what year did you get your undergraduate and master's?
Undergraduate in 2006, master's 2011.
Mr. Owens, you heard Chief Cox testify about that you've had some approvals for part-time jobs in your capacity as being a law enforcement officer, so you could work things like security.
Correct.
And in those jobs, you generally use your police card, use your uniform, wear a gun.
That's correct.
You did not list those as part of on the affidavit to be shared, did you? And those were, did you knowingly exclude those with any intention to deceive or any deception to this board or anyone else?
No.
Did you feel like you had to put down just your full-time employment?
Yes.
And what about the Army Reserves? Did you, I mean, I don't know, did you consider that a job or do you consider that a service?
Both.
And you knew the Army Reserves on your application as employment?
Yes. And the reason, if I could expand, is working for the Cobb County Police Department, we list every job we work as secondary employment. Even reserve is listed. And we fill a form out to get approved as the chief stated. So I'm still an employee of Cobb County. I can't work these other jobs unless I get approved by the county. It's my main employer. I work with other jobs as secondary employment. So the county has to approve every job I work. And I fill out a form and get the chief's or the deputy chief's approval. So it's listed as my main employee is Cobb County because I work as an intern, on the police card, etc. And that's why I list the police department as my employee.
And the not putting the reserves on your affidavit for sure as a place of employment, intentional or knowingly?
No, because it is considered a part-time job as well. Reserve is a part-time job. It is part-time. Some people, sometimes it can be a full-time, depending on if you're deployed for a long period of time, but normally it's 1 day a month, and then 2 weeks out the year. So it's considered part-time employment as well, which is I consider another secondary employment
And in the last 6 years, were you ever deployed for any particular time that would have made you a full-time employee of the military?
Not the last 6 years.
And, Mr. You are admitting to this board that you did not fill out the affidavit, which should have included your high school graduation and high school location, name of it, and your graduation date.
Yes.
Was that knowingly or intentionally was done with any type of deception to this board or any other reason?
Not at all.
And you, in fact, do fit and meet the qualifications to be a candidate for the sheriff of this county?
Absolutely.
Mr. Owens, jobs I read off earlier of the other employers, the Monticello Nightclub, Home Depot, Atlanta Country Club, North by Northwest Office Park, Synovus Bank, and the U.S. Army Reserve. Who pays you when you get a check for services performed by those employers? Who pays you the money? Is it Cobb County that you're saying, and Cobb County pays you, or is it specific entities?
The specific entities.
So that would you agree that makes you an employee of those entities when you're doing that work with them?
I don't agree.
So you don't feel that you're an employee being paid by them?
No. In some of those, but just what you mentioned, I'm a contractor. And I sub those jobs out. Some of those jobs I don't even work. Other guys work those jobs. I don't work them. I'm the part-time. Guys work the jobs. I don't work on those jobs per se. I put other officers working.
When it's time to pay taxes on those jobs and it's time for your 1099, whatever, is that you're the one having to pay the taxes on those?
It's to my company's name.
You have a company, a company you're employed by now. Like you have a company.
LLC.
Oh, okay, that wasn't on your form either, that you had that you're running. So you're running a business also where you employ other peace officers. What's the name of that business?
Owens Security Consultants.
Okay, and why was that not also on your form?
It's not an employee. I'm the owner.
That's not a employee.
No, the list said it's your employee.
Okay, I'll move on from that. I think everybody got the gist of that. Coming back to your affidavit for sheriff. I need to show you this to you, sir.
I'm sorry?
You can see what I'm going to present the witness with, just so you. I'm just going to ask him to read sections.
You want to talk about the original?
I can use this if you don't want. Mr. Owens, on your affidavit for sheriff, somebody with employment here, but if you can read, if you need glasses or whatever, let me know. From this portion that starts "I shall" until the end of the page, I'll let you hold it if you want to hold it.
You can read it. You have it.
No, sir, I'm asking you to read it. I want to make sure that we're on this.
It's what I signed.
So this is correct, you signed. So I'll read it aloud, the section I'm talking about. I shall file an affidavit with the election superintendent by the close of business on the third business day following the close of the qualifications period. I have obtained a high school diploma or its recognized equivalent in education training and established by the Georgia Peace Officers Standards, Training Council, et cetera, et cetera. You obviously knew this is a requirement, I believe. Why did you come in here today and suddenly present those documents?
Well, obviously, I didn't know the requirement, because if it would have known the requirement, I would submit it when I was supposed to. When I asked the certifying official, was I missing anything? She said everything appeared. So I took it as such.
Did you sign this?
I did.
And this document was notarized and sworn to?
Yes.
And on this document, that it says you are supposed to turn that in within 3 days after qualifications.
That's what it says.
Yes or no? Yes?
I said yes.
Okay. That's all the questions I have.
Okay.
No more questions from me.
Okay. Any more witnesses? Oh, I think a board member has a question.
I'd like to ask Mr. Owens a question.
Yes, sir.
What was the date that you joined the reserve?
I got out of the active duty in 1987, and I've been in the reserve since '87. I just retired last year with 36 years.
When did you join the Army?
I joined the Army in 1983.
Okay. When did you come employed by the Cobb County?
In 1989.
Okay, thank you.
questions?
When did you establish your, company?
Maybe probably about 8, not exactly sure, 8, 9 years, not exactly sure if it was 8 or 9.
Okay. Any more witnesses?
No, Your Honor.
No, sir. Summations?
Whoever you want to go first, sir.
You can go first.
Okay. In summation, to make this short and sweet, you heard Mr. Owens himself say not only did he not list 7 jobs, we're actually up to 8 now, that he actually owns the business, that he runs other officers and other part-time jobs, and that he pays the taxes on those things. You heard from Chief Cox that when he is working those jobs, comp insurance is provided by those employers. Just general knowledge, what you guys know on that, you can't do that unless the person's an employee of your company, put them under your and then we also have the fact that he did not turn in any kind of affidavit. He didn't even do what other candidates did and try to substitute that with a high school diploma, certified copy of that, anything, until today. So if I hadn't brought this challenge here today, he was never compliant. And as you saw me have him read this, attempted to get him to read this, and he wouldn't read it because it hurts, I imagine. Nobody wants to personally hurt somebody. But it says, I shall do these things. And he signed it, notarized it, turned it in, understood it. Like he said, he's a major with the Cobb County Police Department. A major. And he was a commander in the United States military. I know this man can read orders. I know he can understand them. I don't know why he didn't follow them. Again, this isn't a clerical error. Up on one thing. I don't know how far the rabbit hole goes. We're down up to 8 employers now he left off of his force. He didn't turn in this. It's just, I don't know. It's more than a clerical error. And if you're going to run and you're going to be the chief law enforcement officer of this county, you got to start by following the rules. And at least following the rules that say what you need to do to even get in the game. And he didn't do that today. And for that reason, he should be struck from the ballot. Thank you.
Ladies and gentlemen, the reasons why you can and cannot get struck from a ballot on a Georgia election. But the case that I've read, at least the Georgia Supreme case law and the Georgia Appeals case law, really does not go to the form of the qualifications and candidacy to run for the office, but whether the person that wants to be on the ballot is actually qualified for that position. That's the reason you're here today. Going back, I would like, I know Ms. Bettifor testified that she did not require to actually review the affidavits and verify whether they're true or not, or whether or not somebody is qualified to be on the ballot to be a candidate for the Sheriff's Department or any other office in Cobb County. And I would submit to you that that's simply not true, because the case law speaks otherwise. Goforth versus Poitras, which is a 1630 Federal 22nd, 5th Circuit, 1981 case. A gentleman by the name of Raymond Goforth wanted to run for the sheriff of his county, but he did not have a high school diploma. He went to the chairperson of the Democratic Party to say, please put me on the ballot to be a candidate for sheriff. She said, you have your high school diploma. Or your general equivalency, or you need to go get it and bring it back so I can declare you a candidate and put you on the ballot. That particular Mr. Goforth chose not to do so. He chose not to go get a high school equivalency diploma or a high school education, and the chair, in review qualification, disqualified him from putting it on the ballot to the Board of Elections in that county. We put the burden on the chair. It's not a work process. It's an evaluation of whether the candidate is qualified to run for that office. That's what happens in a partisan election. If you did not want to qualify for the Republican or Democratic Party, you would have to take these same paperwork to the Board of Elections. It's not that you can't run. It's not that you can't do it. It's just partisan. By the Democratic Party taking responsibility for accepting the documents of a candidate to run for office in this county, they are declaring to you that they will ensure the candidate is qualified. And if they're not, they will tell them. Grogan versus Paulding County Democratic Executive Committee. Mr. Grogan was disqualified for sheriff, Democratic chair, because he didn't have his fingerprints run. You've all heard today that Mr. had his fingerprints run. And how did she know to do that? She knew to do it because as chair of the Democratic Party, it was her responsibility to look into each candidate and make sure they're qualified. Because this isn't a little deal. This is a big deal. When the chair of our Democratic Party or Republican Party in this county, a county of 760,000 individuals, we want these chairs to fulfill their responsibilities. And this is one of them. When she accepted Mr. Owen's documents, she is certifying to you that he is qualified to be a candidate on this ballot in the May 19th election. Next set of case law. Again, case about running for Jolly versus Grantham at 206 Georgia Appeals 100. It's a 1992 case. In this case, the sheriff candidate, Jolly, Mr. Jolly, was a military. He was a longtime member of the military, over 30 years in service. He was about to retire, and what did he want to do with his retirement? He wanted to run for sheriff of his county. He had not retired, and when he filled out the affidavit for sheriff, the same for sheriff that you have before you today, he put down on his affidavit specifically retired federal service. In fact, at the time that he put on the application retired federal service, he actually continued to be employed in the federal government for the next 6 months. His challenger, the other candidate that won for sheriff, challenged his candidacy qualifications because he said by putting retired federal service on his sheriff's affidavit, he was misleading and not truthful, and therefore should be disqualified. The Court of Appeals said, even though it might have been a false statement at the time, it was not intentional, there was no knowingly intent to deceive, to deception, to not lie with the affidavit, that he was qualified to run as sheriff, even though the only thing he put on that application was retired federal service, when he in fact did not retire, he hadn't put any other information on that application. Because the case law looks at whether the person is qualified to run for office after the chair of the county has qualified them and accepted their documents. The courts are erring on the side of allowing people to run for public service. We want people to run for public service. That's what the courts in Georgia have said, are saying by making these decisions. And in Mr. Herndon's case, he says, well, we can't let Mr. Owens run for sheriff because he's committed false swearing. In this case, in the job was specifically that, except for you're committing the crime of false swearing. If there is something misleading and actually, if you knowingly put something untrue and false on your affidavit, the most you can ever be prosecuted for is a misdemeanor, because there is a specific statute that addresses that. And even if he did that under the Jolly case, he was still qualified to run as a candidate on the sheriff's ballot in the primary election. lots of cases that review qualifications of candidates to run for office. One of the most newsworthy, probably over the last 10 years, 12 years or so, Handel versus Powell, 284 Georgia, 550, 2008. This year, the Secretary of State, Karen Handel at the time, challenged the residency requirement of an individual wanting to run a public service commission. She said he put his homestead as Towns County, and Karen Handel argued that his residence was actually right here in Cobb County. It's because he owned two. And Karen Handel, Secretary of State, said he could not run in Towns County for public service commission for that district because he filed a homestead exemption here in Cobb County. So the board and the Secretary of State Public Service Commission, you have the same rules that guide you as this case, the Handel case, where you serve as an administrative hearing officer. So when Ms. Handel went before the administrative hearing officer, she argued the substance, not what was written on the piece of paper, but the substance of the qualifications. And the substance of the qualifications in this case was, Mr. Powell owned a residence in Cobb County and also a residence in Towns County. He spent 60% of the time in Towns County. He voted in Towns County. He went to church in Towns County. He may get his homestead exemption, his tax exemption from Cobb County, but 60% of his actual living was done in Towns County. And the administrative law judge in that case said that substantially complies with the requirements for the qualifications to be a candidate to run for office. And that's what we're here to do today. Has Mr. Owens substantially complied with the requirements that are necessary to be on the ballot on the May 19th, 2020 election as a Democratic for sheriff? I submit to you, we brought evidence of his high school degree, we brought evidence of his college degree, we brought evidence of his master's degree, his post-certification, his service with the military, his service with the Cobb County Police Department. Are there admissions on his application? There certainly are. But the case law as it's written, one submits to you that you must be qualified, the time you're qualified is the date of the election. Meaning, regardless of what on your affidavits, just like the post-certification, as long as you fulfill those requirements by the date of the election, you should be allowed to run. And the cases on point for that are McIntyre versus Miller, Supreme Court, 43263 Georgia, 578, which is a 1993 case, versus Thornton, which is 205 Georgia, 753, 99 case. These cases go all the way back to 1945. But the role of this board is to determine, is Mr. Owens qualified? Clearly, based on the evidence presented today, he's qualified, and I ask that you allow his name to remain on that 2020 ballot. And I appreciate your time and consideration today.
Okay, anything else? We're going to go, I need a motion to go into executive session, and we'll deliberate, and then we'll call y'all back in.
I hereby move that we go into executive session.
Second.
All right, all in favor, raise your hand.
motion to come out of executive session.
I'm hereby making a motion that we come out of executive session. Do I hear a second? Second, okay. All in favor, please raise your hand. All right, we're back in regular session now. And we have heard these deliberations, we have heard the sides of these issues. And I'd like to ask if a member has to make.
I'll make a motion.
All right, please speak up.
I make a motion that Mr. Owens is qualified based on the fact that he did submit the affidavit required by whichever the court session is or for qualification in the 72 hours period.
All right, do we have a second?
Second.
All right, have a second, okay. All right, any, all right, all in favor, raise your hand. Thank you. All right, we thank everybody for being here and presenting your side to the case, and I know the outcome is not what some wish, but that is the choice that's been made.
And as you know, you have 10 days to appeal.
Yes, sir, thank you.
So, motion to adjourn.
All right. We have a motion to adjourn.
I move to adjourn.
All right,
Second.
and have a second, all right. All in favor, please raise your hand. Thank you. Thank everybody for being here, like particularly under these circumstances. Yes, sir.